be seated. Your next witness.
Your Honor, our next witness is Adam Waldman, and I will start the questioning, and then Mr. Rottenborn split that with me, and we'll be questioning next, and then it will be Mr. Depp's counsel.
All right, thank you.
Morning. My name is Elaine Brettahoff, and together with Ben Rottenborn, we represent Amber Laura Hurd. Will you please state your name and address?
Sure. It's Adam Robert Waldman, Washington, D.C.
And what is your current occupation?
Attorney. I'm also involved with a skincare company in a variety of capacities.
How long have you been an attorney?
I think since 1995.
Do you currently represent John C. Depp II, who I will be referring to in this deposition as Mr. Depp or Depp?
I do.
And is this representation an attorney-client representation?
It is.
Does it include any other type of representation of Mr. Depp other than as an attorney-client?
I would instruct the witness not to answer that question on the grounds of attorney-client privilege and attorney work product. He can't answer that question without disclosing communications between himself and his client, Mr. Depp. As you're aware, Ms. Brettahoff, the court has ruled that Mr. Depp has not waived attorney-client privilege and will not be waiving attorney-client privilege. So you're aware of that.
So, Mr. Chu, I'm not sure that you heard my question. I was actually asking him if he had any other type of representation relationship with Mr. Depp other than as an attorney-client.
I think he can answer that yes or no, but I would instruct the witness on behalf of Johnny Depp not to disclose any communications you've had with your client.
No.
So just so we're clear, since we had a little bit of record back and forth, the only way in which you represent Mr. Depp is as an attorney-client representation. Is that correct? I'm sorry, Mr. Waldman?
I believe that's true.
Okay. And you are here today providing this deposition under a subpoena and then subsequent notice, correct?
Yes.
And when did you first become Mr. Depp's counsel?
I think that it was around October 2016.
And what is your role in this case as counsel for Mr. Depp?
Objection. I would instruct the witness not to answer that question.
Okay, I'll follow the instruction.
When did you first meet Mr. Depp as opposed to first start representing him?
I first met him in October of 2016.
How is it that you came to meet Mr. Depp?
The general counsel that I referenced a moment ago asked me to go and have a meeting with him, with Mr. Depp, and to talk about a financial problem that he was having.
Did you enter into a written representation agreement with Mr. Depp when you began your representation?
I would instruct the witness not to answer that question. That calls for attorney-client privilege.
Okay, I follow the instruction.
Have you entered into more than one representation agreement with Mr. Depp during the course of your representation?
Same instruction not to answer. You can't answer that without disclosing attorney-client communications and attorney work product.
Mr. Waldman, when did you consider your attorney-client relationship with Mr. Depp to have begun?
I believe it began the night I met him, actually.
Sometime in October 2016?
Yes, ma'am.
Has the attorney-client relationship between you and Mr. Depp been severed at any point between October 2016 and the present?
Would instruct the witness not to answer that question on the grounds that you can't answer that question without disclosing attorney-client communications.
Okay, I accept the instruction.
As Mr. Depp's attorney, you have provided him with advice. Is that fair to say?
That's correct.
And you have charged Mr. Depp for your advice, correct?
I would instruct the witness not to answer that question. You can't answer that without disclosing attorney-client communications, and the fee arrangement in any event is irrelevant. But I'm instructing him not to answer on the grounds of privilege.
I accept the instruction.
Mr. Waldman, when you provide legal services in an attorney-client relationship, your understanding of that is that you provide advice and your client in turn compensates you in some manner. Would that be fair to say?
Yes, as a general matter, that's how I understand an attorney-client relationship. Yes.
And has Mr. Depp paid you for advice?
I would instruct, I do instruct the witness not to answer on the grounds of attorney-client privilege. You can't answer that question without disclosing your communications with Mr. Depp.
I accept the instruction.
Well, let's go general again and see if maybe we can work at it from that perspective. So in your relationship with your clients, you provide advice and it's up to the client to determine whether to follow that advice. Would that be fair to say?
As a general matter, I do agree with that statement, yes.
All right. And by the same token, it would be up to the client to determine whether to reject your advice in whole or part, correct?
You're still speaking in general.
Correct.
In general, yes.
Okay. Now, did your relationship with Mr. Depp, and I'm talking about your attorney-client relationship, deviate from those general principles that in some way Mr. Depp is not permitted to follow or reject your advice?
Would instruct the witness not to answer the question based on attorney-client privilege.
I accept the instruction.
Now, Mr. Depp has the right to terminate your representation at any time. Is that correct?
But yes, I think it's true.
I think we need to let...
Would be free to terminate at any time.
My apologies, Mr. Waldman. I didn't realize you were still talking. Did you finish?
Yes, I did. Thank you.
Now, has Mr. Depp terminated your representation of him at any time between October 2016 and the present?
That's the same question that I instructed Mr. Waldman not to answer before, just stated in a slightly different way, so I would instruct the witness not to answer that question.
I accept the instruction.
Now, and Mr. Depp, as the client in your relationship, is in the position to make the final decision regardless of your advice. Would you agree?
I would instruct the witness not to answer that question. I don't know that I know he can't answer that question without disclosing communications with Mr. Depp. So I instruct the witness not to answer.
I accept the instruction.
Mr. Waldman, if you were advising a client in an attorney-client relationship and you were in settlement negotiations, would it be you or the client who has the ultimate decision-making ability?
But to speculate about the question, yes, generally the client would be responsible for deciding, the ultimate outcome of the settlement. Yes.
Now, you met Mr. Depp after he and Amber Heard had split up. Is that correct?
That's correct.
And you met Mr. Depp after he and Amber Heard had reached a settlement in their divorce. Is that correct?
That's my understanding.
So you have no personal knowledge of anything that went on during their marriage. Is that fair to say?
Well, it depends what you mean by personal knowledge. I wasn't there, if that's what you mean. Correct.
You never witnessed any interaction between Mr. Depp and Amber Heard prior to October 2016. Is that correct?
That's correct.
And you have no personal knowledge of any conduct by either of them against the other prior to October 2016. Is that correct?
Again, if you're asking me, do I have any knowledge of their conduct? I think I have knowledge of their conduct. I think maybe you're asking me, did I witness conduct?
I'm asking personal knowledge, which would mean you would have had to have witnessed it.
If you're asking whether I've witnessed it, the answer is no.
Now, your initial knowledge of the relationship between Mr. Depp and Ms. Heard was based on your interviews with Mr. Depp. Would that be fair to say?
I would instruct the witness not to answer that question because he can't even answer yes or no without disclosing the substance of communications with his client, Mr. Depp.
I accept the instruction.
Once you came into Mr. Depp's life and became his counsel, Mr. Depp filed with your assistance a number of lawsuits. Would you agree?
Yes.
Did Mr. Depp terminate Tracy Jacobs as his agent before or after you became Mr. Depp's counsel?
Mr. Waldman, I would instruct you not to answer that question if doing so would require you to disclose any communications you had with Mr. Depp.
It would.
How long had Tracy Jacobs been Mr. Depp's agent at the time Mr. Depp terminated Tracy Jacobs?
And again, Adam, same instruction to the extent that that answering the question requires you to disclose communications that you had with Mr. Depp. I would instruct you not to answer the question.
It would.
Was it Mr. Depp's decision to terminate Tracy Jacobs?
Again, I would instruct you not to answer that question because that could only have come from Mr. Depp in the communication with you.
I accept the instruction.
After you began representing Mr. Depp filed a lawsuit against Joel Mandel, Mr. Depp's former business manager, correct?
That's correct.
And you represented Mr. Depp in that lawsuit against Joel Mandel and his company, did you not?
I did.
But it was Mr. Depp's decision on whether to file the lawsuit against Mr. Mandel and his company. Would you agree?
I would instruct the witness not to answer that question because it would require disclosure of communications between Mr. Depp and Mr. Waldman as to who was advising who as to filing the case against TMG and the Mandel brothers. So I would instruct you not to answer that.
I accept the instruction.
Did Mr. Depp have the ultimate decision making ability with respect to the lawsuit against Mr. Mandel and his company?
And again, I would instruct you not to answer to the extent it requires you to disclose attorney-client communication.
It would.
After you began representing Mr. Depp filed a lawsuit against Jake Bloom, Mr. Depp's former attorney, correct?
That's correct.
And you represented Mr. Depp in that lawsuit against Jake Bloom and his law firm, did you not?
I did.
But it was Mr. Depp's decision on whether to file the lawsuit against Mr. Bloom and his law firm. Is that correct?
Again, I would instruct the witness not to answer to the extent it requires him to disclose attorney-client communication.
It would.
And Mr. Depp, though, was the ultimate decision maker in connection with any decisions made in the litigation against Mr. Bloom and his law firm. Would you agree?
Same instruction not to answer. It's basically the same question, gussied up a bit. So same instruction not to answer.
I accept the instruction.
After you began representing Mr. Depp filed a lawsuit against the Sun newspaper and its editor-in-chief, Dan Wooten, correct?
Correct.
For purposes of this deposition, I may refer to the lawsuit against the Sun and its editor, Dan Wooten, as the UK lawsuit or the UK litigation. Will you understand those references to mean this?
I will.
What was your role in the UK litigation?
I would instruct the witness not to answer that question because it necessarily requires him or would require him to disclose his communications with his client, Johnny Depp.
It would.
You represented Mr. Depp throughout the UK litigation, correct?
Again, I would.
And Mr. Depp alleged in the UK litigation that the Sun and Dan Wooten had committed libel by accusing Mr. Depp of being a, quote, wife beater, end of quote, and committing domestic violence against Amber Heard, correct?
That's true.
It was Mr. Depp's decision on whether to bring the UK lawsuit against the Sun and Dan Wooten, correct?
And again, I would instruct the witness not to answer I would instruct him not to answer because it perforce would require him to disclose attorney-client communications as to the thought process that went into filing that particular lawsuit.
I accept the instruction.
After you began representing Mr. Depp filed suit against Amber Heard, his former wife, correct?
That's correct.
And you represented Mr. Depp in the lawsuit against Amber Heard from March 1, 2019 up until October of 2020. Is that correct?
Yes.
And it was Mr. Depp's decision on whether to file the lawsuit against Amber Heard. Is that correct?
Would instruct the witness not to answer that question based on attorney-client privilege.
I accept the instruction.
And Mr. Depp is alleging in this lawsuit that Amber Heard defamed him by suggesting that he had committed domestic abuse against her, correct?
Yes.
As part of your representation of Mr. Depp, you contacted potential witnesses. Is that correct?
Again, I would. That is attorney work product, and that is protected in Virginia. So I would object on that basis, but you can answer that question yes or no.
Yes.
You also spoke with the press on Mr. Depp's behalf, did you not?
And I would instruct the witness not to answer to the extent that it requires disclosure of any communications between yourself and Mr. Depp.
It would.
And therefore?
And therefore I accept the instruction.
How frequently did you communicate with the press on Mr. Depp's behalf?
I would instruct the witness not to answer that question because impossible to do so without disclosing attorney-client privilege.
I accept the instruction.
Why did you communicate with the press?
Same instruction not to answer on the same grounds.
I accept the instruction.
What were you hoping to gain?
Same instruction not to answer the question.
I accept the instruction.
You remain Mr. Depp's primary counsel for all of his affairs. Isn't that correct?
I'm going to instruct the witness not to answer that because I don't think you can answer that without disclosing your communications with Mr. Depp, and we have to be consistent.
That's true, and I accept the instruction.
Mr. Waldman, I'm going to ask you to take a look at what has been marked as exhibit number 3. Did there come a time in 2018 that you contacted Rolling Stone about writing an article about Mr. Depp?
And to the extent that you cannot answer it without disclosing communications with Mr. Depp, I would instruct you not to answer.
I think it would implicate discussions with Mr. Depp, so I accept your instruction.
The author of this article, which was published on June 21, 2018, is Stephen Roderick. Were you present when Mr. Roderick interviewed Mr. Depp?
You may answer that question yes or no.
It's not yes or no. I was there for some of it.
Okay. Was the Rolling Stone interview before or after Mr. Depp filed suit against the Sun and Dan Wooten?
I'm not sure.
Do you recall whether the publication of this Rolling Stone article was before or after Mr. Depp filed the lawsuit against the Sun and Dan Wooten?
I don't.
I'm going to ask you to take a look at page 10. And it says on page 10, it was Adam Waldman who first contacted Rolling Stone about writing a story about the injustice being done to Depp's reputation and bottom line. Do you see that? Well, before you go there, Mr. Waldman, I asked you a question. I just read that and said, do you see that? Can you answer that question?
I thought I answered yes, but yes, ma'am.
Okay, thank you very much. And is that an accurate statement?
No.
What is inaccurate about it?
It says it was Adam Waldman who first contacted Rolling Stone. That's incorrect.
What is correct?
What is correct is that I was not the first to contact Rolling Stone.
Who first contacted Rolling Stone?
Mr. Depp.
I'm going to ask the question, notwithstanding, why did Mr. Depp contact Rolling Stone?
I would instruct you not to answer that question.
I accept the instruction.
Did Mr. Depp authorize you to have communications with the Rolling Stone to set up this interview?
Instruct you not to answer that question on the grounds of attorney-client privilege.
I accept the instruction.
Did you assist Mr. Depp with publicity on Mr. Depp's behalf?
I would instruct you not to answer on the grounds of attorney-client communications.
I accept the instruction.
In your view, does assisting Mr. Depp with publicity constitute legal work?
The witness has already testified he had one engagement for Mr. Depp, and that was a legal engagement. So I'm going to instruct him not to answer any questions about his communications with Mr. Depp.
I accept the instruction.
In participating in the interview with the Rolling Stones, were you speaking on Mr. Depp's behalf?
And I'm going to instruct not to answer because, again, I don't think you can answer that question without disclosing your communications with Mr. Depp about authority. So I'm instructing you not to answer the question.
It was Mr. Depp's choice whether you said anything to the press relating to Mr. Depp. Would you agree?
I instruct the witness not to answer.
I accept the
Mr. Waldman, you reached out to a number of other publications to speak on Mr. Depp's behalf. Do you recall?
Again, I would instruct not to answer to the extent it requires you to disclose communications that you had with Mr. Depp.
It would, and I accept the instruction.
How many publications did you communicate with on behalf of Mr. Depp?
Same instruction not to answer based on attorney-client privilege and attorney work product.
I accept the instruction.
How many publications did you reach out to on Mr. Depp's behalf relating to the UK litigation?
Same instruction not to answer on the same grounds.
I accept the instruction.
How many publications did you reach out to on Mr. Depp's behalf relating to this litigation?
Same instruction on the same grounds.
I accept the instruction.
How many publications did you reach out to concerning allegations that Mr. Depp had abused Amber Heard?
Same instruction, same grounds.
I accept the instruction.
Mr. Waldman, you had a Twitter account, did you not?
I did.
When did you begin that Twitter account?
I'm not sure of the date.
Approximately when?
I'm not even sure of the year.
Was it prior to 2005, 2010, 2015?
Do you want me to speculate?
I want you to give me your best estimate.
Okay. I'm really not sure of the year. I couldn't put a specific date on it.
Do you
If you
recall?
want to give me ranges, I could try.
Do you recall how many years you had the Twitter account?
Not precisely, no.
Was it more than a year?
I think so.
Was it more than 3 years?
I don't think so.
Now, you had your Twitter account suspended, correct?
Yes, that's true. My Twitter account was suspended.
Do you recall when that was?
Not with specificity, no.
Do you recall why?
Well, I wrote several letters to Twitter to ask why I was suspended for life from their platform. And the response that I received was multiple violations of their policy. So I asked, could they name one example of those multiple violations? And they responded by saying now they were appealing, without my asking them to do so, my suspension. And that's when they sent me another note that I was suspended for life.
So just so the record's clear, so you have been suspended for life by Twitter?
Yes,
Okay. Do you have a Twitter account now?
no,
Do you still communicate with the press relating to Mr. Depp?
And I would instruct the witness not to answer the question to the extent that it requires you to disclose communications between you and Johnny.
it would, so I accept the instruction.
Do you still communicate with the press on Mr. Depp's behalf?
Same instruction, same grounds.
I accept the instruction.
Has Mr. Depp ever asked you not to speak to the press?
Same instruction, same grounds. That, on its face, it would require Mr. Waldman to disclose his communications with Mr. Depp, which he will not do.
It would, and I accept the instruction.
Would you have followed Mr. Depp's direction if he had asked you not to speak to the press?
I will instruct the witness not to answer because it's an end around the attorney-client privilege. Clever, but I'm going to instruct the witness not to answer.
I accept the instruction.
Has Mr. Depp ever asked you not to speak to the press about issues involving he and Amber Heard?
We'd instruct the witness not to answer the question on attorney-client privilege.
I accept the instruction.
Would you have followed Mr. Depp's direction if he had asked you not to speak with the press about issues involving he and Amber Heard?
And I will instruct not to answer on the grounds of attorney-client privilege.
I accept the instruction.
Has Mr. Depp ever asked you to correct or retract any statements you made to the press relating to Mr. Depp or Mr. Heard or Amber Heard?
Would instruct the witness not to answer on the grounds of attorney-client privilege.
I accept the instruction.
Would you have followed Mr. Depp's direction if he had asked you to correct or retract any statements you made to the press relating to Mr. Depp or Amber Heard?
Same instruction, same grounds.
And I accept the instruction.
Have you ever asked the press to correct or retract any statements you have made to the press relating to Mr. Depp or Amber Heard?
I want to make sure I understand the instruction. Are you saying you instruct not to answer in the event it implicates privileged conversations with Mr. Depp?
Yeah, I think I'm going to instruct not to answer.
Okay, thank you. I understand. I accept the instruction.
Mr. Waldman, I'm going to ask you to take a look at what has been marked as exhibit number 4. I think I'm going to try to blow it up just a touch. It's kind of hard to read. Okay. And it's an article from July 3, 2020. From Mail Online. This is Daily Mail Online. Do you see that?
I do.
No. Actually, if I'm just going to go to page 8, I'm going to ask you to take a look at the following. It says, Adam Waldman, Depp's lawyer, said afterwards, quote, Amber Heard and her friends in the media use fake sexual violence allegations as both a sword and a shield, depending on their needs. They have selected some of her sexual violence hoax facts, quote facts, end of quote, as the sword, inflicting them on the public and Mr. Depp. Do you see that?
I do.
Did you make that statement?
I believe I did.
Did you make that statement on behalf of Mr. Depp?
Instruct the witness not to answer that question on attorney-client privilege grounds.
I accept the instruction.
Why did you make the statement?
Same instruction, same rationale. You can't answer the why question without disclosing attorney-client privilege, so I would instruct you not to answer.
Were you representing Mr. Depp at the time you made this statement?
And in any event, I'm going to instruct the witness not to answer that question on attorney-client privilege grounds.
I apologize. I actually didn't hear the question. I can agree with the instruction, but I probably should hear the question.
Fair enough.
Amy, could you read that back, please? Thank you.
One moment. Were you representing Mr. Depp at the time you made this statement?
I would instruct the witness not to answer on attorney-client privilege grounds.
And thank you. I accept the instruction. Sorry for the repetition.
Did you discuss this statement with Mr. Depp before making the statement?
On same grounds.
Yeah, I accept the instruction.
Did you discuss the statement with Mr. Depp after making the statement?
Same instruction, same grounds.
I accept the instruction.
Was Mr. Depp aware, either before or after, that you were making this statement?
Same instruction, same grounds.
I accept the instruction.
Did you make this statement with Mr. Depp's authorization or agreement?
Same instruction, same grounds.
I accept the instruction.
Was Mr. Depp aware that you were speaking with the press?
Same instruction, same grounds.
I accept the instruction.
Did Mr. Depp ever ask you to retract or correct this statement?
Same instruction, same grounds.
I accept the instruction.
If Mr. Depp had asked you to retract or correct this statement, would you have retracted or corrected it?
Same instruction, same grounds.
I accept the instruction.
If Mr. Depp had told you that the statement was not correct, would you have corrected or retracted it?
Same instruction, same grounds.
I accept the instruction.
Did you rely upon any statements or evidence from Mr. Depp in making this statement?
Same instruction, same grounds.
Yes, I accept the instruction.
And if you could bring up exhibit number 5. Mr. Waldman, I'm going to be asking you a question about a specific statement in this one. If you would like to read the article first, you are certainly at liberty to, and you can take control now and do that.
Thank you, I will.
It says, this is, I guess, I didn't set the stage here. This was the Daily Mail published on July 3rd, 2020. And I'm going to now direct your attention to page 9. Depp's lawyer, Adam Waldman, said the various discrepancies prove that nothing heard and her friends said about the events of May 21, 2016 could be considered credible. Do you see that?
Hearsay.
Then I'm going to direct your attention, Mr. Waldman, to the next statement. Quote, quite simply, this was an ambush, a hoax. They set Mr. Depp up by calling the cops, but the first attempt didn't do the trick. The officers came to the penthouses, thoroughly searched and interviewed, and left after seeing no damage to face or property. So Amber and her friends spilled a little wine and roughed the place up, got their story straight under the direction of a lawyer and a publicist, and then placed a second call to 911. Do you see that statement?
I do.
Did you make those statements?
There are two parts to what you've shown me. The first part didn't have quotation marks around it.
And I'm not asking about that. I'm sorry.
Where it said nothing could be considered credible, that's not quoting me. The part with the quote marks, I believe I said that, yes.
So starting from quite simply through (911), you stated all that. Is that correct?
Yes, I believe so.
Okay. Did you make these statements on Mr. Depp's behalf?
Instruct the witness not to answer on the grounds of attorney-client privilege.
I accept the instruction.
Why did you make these statements?
Same instruction, same reason.
I accept the instruction.
What were you trying to convey to the press in making these statements?
Same instruction, same reason.
I accept the instruction.
Did you discuss this statement with Mr. Depp before making these statements?
Same instruction, same reason.
I accept the instruction.
Did you discuss these statements with Mr. Depp following making these statements?
Same instruction, same rationale.
Yes, I accept the instruction.
Was Mr. Depp aware either before or after that you were making these statements?
Same instruction, same reason.
I accept the instruction.
Did you make these statements with Mr. Depp's authorization or agreement?
Same instruction, same basis.
I accept the instruction.
Was Mr. Depp aware you were speaking with the press?
Same instruction, same basis.
I accept the instruction.
Did Mr. Depp ever ask you to retract or correct these statements?
Same instruction, same basis.
I accept the instruction.
If Mr. Depp had asked you to retract or correct these statements, would you have retracted or corrected them?
Same instruction, same basis.
I accept the instruction.
If Mr. Depp had told you these statements were not correct, would you have corrected or retracted them?
Same instruction, same basis.
I accept the instruction.
Did you rely upon any statements or evidence from Mr. Depp in making these statements?
Same instruction, same basis.
I accept the instruction.
Mr. Waldman, I'm going to ask you to take a look at exhibit number 6. This was another Daily Mail online, July 3, 2020. And if you would like to go ahead and read the article, this would be a good time to do it.
Thank you.
Mr. Waldman, we were looking at Waldman exhibit number 6, and it's the Daily Mail from July, just lost her there, but July 3rd, 2020, and you were going to scroll through it, and I think we had some technical difficulties, so we took a break. Have you had an opportunity to review it, or do you need to now?
No, Ms. Bredoff, I just saw the screen for the first time, so may I read it now?
Absolutely. I'm going to ask you to turn to what is the 11th page, the last page you just finished reading, and I'm going to direct your attention to some specific words that are attributed to you. Do you see that it says Depp's attorney Adam Waldman said? Right here. Okay. You see Depp's attorney Adam Waldman said. Do you see that there, Mr. Waldman?
I do.
Okay. And then I'm going to direct your attention to specifically the end of Ms. Heard's abuse hoax against Johnny Depp. Do you see that?
I do.
Did you speak the words, quote, the end of Ms. Heard's abuse hoax against Johnny Depp?
I'm not sure. It appears as I look at this that there are quote marks around the statement, and that suggests that I did. I don't remember saying these particular words, but it appears so.
Do you have any reason to believe that you did not say the end of Ms. Heard's abuse hoax against Ms. Johnny Depp?
No, I have no reason to doubt that.
Were you representing Mr. Depp at the time you made this statement? I'm going to refer to it as a statement. I'm taking specific words, Ms. Heard's abuse hoax against Johnny Depp. But were you representing Mr. Depp at the time you made the statement that included Ms. Heard's abuse hoax against Johnny Depp?
Instruct the witness not to answer based on attorney-client privilege.
I accept the instruction.
Why did you make this statement?
Same instruction, same basis.
I accept the instruction.
What were you trying to convey to the press in making this statement?
Same instruction, same basis.
I accept the instruction.
Did you make the statement on Mr. Depp's behalf?
Same instruction, same basis.
I accept the instruction.
Did you discuss this statement with Mr. Depp before making the statement?
Same instruction, same basis.
I accept the instruction.
Did you discuss this statement with Mr. Depp following making the statement?
Same instruction, same basis.
I accept the instruction.
Was Mr. Depp aware either before or after that you were making this statement?
Same instruction, same basis.
I accept the instruction.
Did you make this statement with Mr. Depp's authorization or agreement?
Same instruction, same basis.
I accept the instruction.
Was Mr. Depp aware you were speaking with the press?
Same instruction, same basis.
I accept the instruction.
Did Mr. Depp ever ask you to retract or correct this statement?
Same instruction, same basis.
I accept the instruction.
If Mr. Depp had asked you to retract or correct this statement, would you have done so?
Same instruction, same basis.
I accept the instruction.
Mr. Waldman, I'm going to ask you to take a look at what has been marked as deposition exhibit number 11. And if you want to take a moment, I'm going to try to make it. Mr. Waldman, I'm just going to ask you, it's just kind of 2.5 pages. Go ahead and take the moment to review it, and then I'll ask you some questions.
Thank you. Okay, thank you. I've read it.
Okay. So directing your attention to exhibit number 11. So, because there's a number of these, so maybe we can just clear it up right from the start. So we have conversation. If you look at the top, conversation, 6 messages, 3 parties, over 209 minutes. And it has this first one, it has a date and a time, and it has a telephone number. Do you see that?
I do.
Okay. And then it has some email messages or text messages. It looks like it starts with Keith Bishop. Do you know who Keith Bishop is?
I do.
And who is he?
Keith Bishop is a publicist who lives in London.
And for what publication?
Oh no, he's a publicist. He's an advisor on media.
I see. Did you, at any time, did you or Mr. Depp ever employ Keith Bishop in any kind of public relations role?
Mr. Waldman, I would instruct you not to answer any. I would instruct you not to answer the question to the extent that it would require you to disclose any communications you had with Johnny, either receiving or giving.
I would not be able to answer without doing so, so I accept the instruction.
Okay, and then Mr. Bishop says, and this is on 1/28/2020, Adam, I can confirm a meeting with the Mail Online for Monday, 17 February at 10 a.m. You see that?
I do.
So did you, in fact, have a meeting with the Mail Online on 17 February?
I couldn't say sitting here now definitively that we met on Monday the 17th of February, no. But I see this and it wouldn't surprise me if we had.
And was Mr. Depp with you when you had the meeting?
I believe Mr. Depp was with me when we had this meeting.
And you were representing Mr. Depp at the time, correct?
I would instruct the witness not to answer that question based on attorney-client privilege.
I accept the instruction.
When did you obtain the audio tape that you're referencing in this text message?
And I would instruct you not to answer the question to the extent it would require you to disclose any communications you had with Mr. Depp, your client.
It would, and so I won't be able to answer the question.
What tape did you provide to the Mail online, the Daily Mail?
In this, are you asking, forgive me, in this instance relating to this text?
Yes.
My recollection is that I gave a pair of audio tapes, actually, to them. Whether that occurred sequentially or at the same time, I don't remember, but I provided them 2 tapes.
What training have you had in domestic violence?
None.
Have you ever represented any clients who have either been accused of domestic violence or had domestic violence committed on them other than Mr. Depp?
No.
And of course, you never saw any, as we would say, element or elements of things that Ms. Heard claimed, right?
I never saw any element or elements of things she claimed. Do you mean, did I ever see evidence with my own eyes that something she was saying was false?
Yes.
Yes, to some extent I have seen evidence of things that show her statements to be false.
Before we get there, as best you can recall today, who are the eyewitnesses that you, among the 29 or so that you referred to in the text to Christian Carino, that you believe disprove Ms. Heard's claims of abuse by Johnny Depp?
Okay, good. It's also probably easier to answer by taking a particular incident rather than just thinking of names of people. So maybe this is a good illustration that is a helpful answer. On May 21st, 2016, and I always view this as one of her central claims. It was the one she put on the cover of People magazine. It's the one she led with when she went to get her temporary restraining order. The phone to the face incident on May 21st, 2016. That's her claim, and that she was further beaten by some appendage of Mr. Depp in the face, and her hair was pulled. And she showed up on the 27th in court with a lot of bruises on her face. So there are 2 police officers, one domestic violence trained female police officer, who've testified over and over and over that there was no damage to the penthouse, which Ms. Heard claimed was destroyed. That's a direct quote, destroyed. There are, what I can think of, 9 other witnesses, the majority of whom are either neutral or actually Ms. Heard's own witnesses, who have testified in various forms, various times, that there were no injuries to her face whatsoever between the 21st and the 27th, when suddenly there were bruises.
Who are those 9?
Let's see. Laura Divinier, Melanie Inglesi, Amber's own primary makeup artist. Laura Divinier was Ms. Heard's assistant and decorator, and now works for Elon Musk. Hilda Vargas, Mr. Depp and Ms. Heard's at the time housekeeper. Samantha McMillan, who was Ms. Heard and Mr. Depp's stylist, a good friend of Ms. Heard's. Isaac Baruch, Ms. Heard's and Mr. Depp's friend, close friend, and Ms. Heard's neighbor in the penthouses. Okay, so continuing on, the witnesses, a list of some witnesses to the 21st, to her claims of violence and damage to the apartment. Trinity Esparza, who was the head of the concierge desk at the Eastern Columbia building, and a friend of Ms. Heard's also. Cornelius Harrell, who I think also worked for the concierge desk, or in any event worked for the Eastern Columbia building, and met with Ms. Heard on the 22nd of May which meeting was captured on CCTV also. Alejandro Romero, who I believe is head of security at the Eastern Columbia building. And I think Brandon Patterson also testified about the absence of bruises. And I should even distinguish, because we're talking about the notion of a hoax, I should distinguish these people specifically have given testimony that Ms. Heard was uninjured between the 21st of May up into perhaps the 25th or 26th of May. And then, of course, she appeared bruised again on the 27th. Some of them have testified that even after the 27th, they were with her and she appeared and that she appeared bruised. But during that period between the 21st and the 27th, I'm not sure if I've listed 9 plus the 2 police officers, but I think that's an illustration of what I was referring to when in the question you asked me about.
Can you please pull up the document labeled ARW 660, please? Sorry, but you do believe that the pictures and videos Marilyn Manson sent you helped disprove Ms. Heard's allegations, correct?
As to that incident, Thanksgiving, perhaps 2013, I think those videos and photographs, yes, demolished her claim.
Have you communicated with other social media users about this case other than public messaging platforms? Let me ask that differently. Have you communicated privately with other social media users about this case?
Other social media, I want to make sure I'm precise. Other social media users?
Yes.
That group would include almost everybody on Earth.
Have you provided information about this case to other social media personalities who then post that information?
I've provided information episodically to what I would call internet journalists, and I'll define that as journalists who are not affiliated with, you mentioned, I think, NBC a moment ago, or a mainstream media outlet.
Have you communicated with a social media user who goes by the name That Umbrella Guy?
I've had several phone calls with the person who goes by the name That Umbrella Guy. I don't actually know his real name.
Have you communicated with him other than through phone calls?
I don't remember doing so, no.
What are other, well, let me ask you this. Have you communicated in a similar fashion with someone on social media who goes by the name That Brian Fella?
Yes.
What about someone who goes by the name The Real Laura B?
Yes.
And have you communicated to those individuals listed evidence that you believe suggests that Ms. Heard's allegations are hoaxes?
I would say I communicate with the internet journalists, because we put them in a category calling them that. I've done that. Exactly the same way I would communicate with mainstream media. If they have questions about evidence or the facts, I'll inform them.
And have you, when you communicate with them, do you do so? You testified some by phone, correct?
Yes.
Do you do so by text or messenger platform?
Largely, I think by phone, but if I communicated in writing, it would be probably by signal.
Can you please pull up the exhibits ALH 17001 to 2, please?
Showing on the screen, exhibit 24.
No, my question, well, my first question is, is that in that box where it says first on the record statement from me regarding the body cam to RTL, Adam Waldman, Johnny Depp's attorney, is that a statement that you made to a German media outlet called RTL?
Yes.
And in that statement, you say that LAPD have now opened up a criminal investigation into perjury of Ms. Heard, correct?
Yes.
Did you make a correction to RTL when you learned that the LAPD wasn't in fact investigating Ms. Heard for perjury?
Well, the way you characterize it is not exactly what I would agree with. The LAPD told me that they were investigating the perjury claim at that time. Then sequentially came the statement. Then came notification from the LAPD that it was actually the LA Sheriff's Department that was investigating it, and that was the last I heard about it.
And who notified you from the LAPD that it was allegedly the Sheriff's Department who was investigating it?
The same desk officer at Foothill. And when I say he's the desk officer, I don't know. That's not necessarily the job title.
How did you find his? Do you have his contact information?
I don't think I do. I don't know, but I don't. Well, I'm not sure.
And I'm sorry if I asked you this. How did you come into contact with this desk officer?
I brought a binder of information, including the statements that had been made and the evidence showing that those statements were false.
In your view. So you took a binder to the LAPD and spoke to this desk officer?
Correct.
And was that the only time that you spoke to this person?
The 2 times.
Were they both in person?
Oh, maybe it's 2 or 3 times. No. No, 2 times we're on the phone.
Was the first meeting in person when you brought this binder?
No, the first was on the telephone.
So the investigation was opened up at your request after you brought this binder to the desk officer? Is that right?
I didn't ask him to open an investigation. I filed a claim with the LAPD regarding these perjurious statements that Ms. Heard and her best friend Rocky Pennington had made to a court.
Was that claim that you filed in writing?
Yes.
Do you know whether that claim was produced as part of your document production in this case? Because I certainly haven't seen it.
I don't know that I ever received a copy of it. It was filed in writing with the LAPD. But I don't recall that I ever received a copy of it.
Did you draft it?
No.
So you were talking to the desk officer and he was taking down notes, and is that the writing you were referring to?
Yes.
Did you ever see this alleged written claim?
Yes.
Did you sign it?
I don't recall if I did.
Did you ever speak to anyone other than your client about this alleged perjury investigation, other than your client and the desk officer?
Well, I think this quote that you've shown me to the media would constitute speaking about it.
Did you ever hear anything more about this perjury investigation to the extent it exists at LA Sheriff's Office?
No, I don't think so.
Mr. Waldman, do you have a professional license?
I do.
Do you have your own law firm?
I do.
What is the name of your law firm?
Endeavor Law Firm.
When was Endeavor Law Firm formed?
I think it was in 2005.
And who was it who formed your law firm?
It was I who did it.
And who owns your law firm?
I do.
What is your title at the Endeavor Law Firm?
Managing member, I believe.
And it's none of our business who your clients are, but does the Endeavor Law Firm have other clients other than Mr. Depp?
Yes.
Does Johnny Depp issue you a Form W-2?
I don't think so, no.
Do you receive legal training from Johnny Depp or any of your other clients?
I suppose the practice of law in general is legal training, but if I understand your question correctly, no.
Fair point. Have you ever listed Johnny Depp as your employer on any filings with the IRS?
No.
But you offer legal services to clients, correct?
Yes.
All right, I'll say, do you offer legal services to the general public?
Probably not to the general public, but I offer legal services. I think that's your question.
All right. Yes, ma'am.
Your Honor, our next one would be Detective Sandanaga, Sandanaga. It's about 20 minutes.
All right, let's go ahead and
Okay.
have that witness. Is that, and go ahead.
We start the questioning.
All right, thank you.
State your name and business address for the record, please.
Marie Sadanaga, Marie, Sadanaga, Sadanaga. And my business address is 100 West 1st Street, Los Angeles, California.
And what is your current occupation?
I am a detective with the Los Angeles Police Department, and I am the department's domestic violence coordinator.
What does it mean to be the domestic violence coordinator for the department?
So I am recognized as the person most knowledgeable in domestic violence. I oversee how our department as a whole responds to domestic violence. So I don't investigate cases right now myself. I just make sure that officers and detectives are responding to domestic violence how California State Penal Code wants us to.
And how long have you been with the LAPD?
17 years.
What, if any, policies, procedures, and protocols are in place at the LAPD for domestic violence cases separate from other types?
So once we determine there is domestic violence, we have to determine whether there is a crime. Every time we respond to a domestic violence call, per state law, we need to document whether it's a crime or just an incident, which would be when there is not a crime, but there's still paperwork done. So that is part of the officer's investigation.
Now, I had asked a little earlier about when the victim is reluctant to press charges. If the patrol officers saw property damage or marks on the face of the victim, even if the victim was not cooperating and did not want to press charges, what would the patrol officers' obligations be back in May 2016 on a domestic violence call?
If officers determined that there was domestic violence, even if a victim is reluctant, our policy is they still make that arrest if the suspect is there or take the report.
So if there are, when the patrol officers arrive at the scene, and this is May 2016, and there are 4 people that are present at the scene, how many of those individuals are the patrol officers obligated to interview? So I'm going to show you the incident call here, and it goes down and it has domestic dispute, and then it says met with victim, looks like check location, verified husband left, victim advised verbal dispute, and refused to give any further information, issued business card. Do you see that?
Yes.
Okay. In May of 2016, was the language victim advised verbal dispute language that patrol officers were trained to provide when they were not going to document anything from the scene?
It can vary, but officers would commonly use the phrase verbal dispute or to document when a report was not taken.
I'm going to ask you to take a look at what has been marked as deposition exhibit number 8. It's dated November 24, 2014. And it's subject domestic violence supplemental report. And it says the domestic violence supplemental report form 15.40.02 has been revised to provide a more concise picture of the history and needs of the victim for the purpose of investigating the crime of domestic violence. Do you see that?
Yes.
What is your understanding of why the LAPD decided that they needed to create a supplemental report form that would give a more concise picture of the history and needs of the victim for the purpose of investigating the crime of domestic violence?
Right. The supplemental includes a lot of questions that are required by California state law. So we included that on it. And the original supplemental was actually created a lot earlier, I believe in 1999. This revision of it added some specific questions to help us look at kind of to do a risk assessment. I'm not sure if the supplemental is attached to this form, but on the supplemental, there's a section where I believe there's like 7 yes or no questions. That is what was added during this revision.
Detective Sadnaga, I'm going to show you what has been marked as deposition exhibit number 9. And do you recognize this supplemental report?
Yes.
Is this the supplemental form that was referred to in exhibit number 8?
Yes.
Okay. Now, if we look at this, and we start out on the left-hand column, and it has a number of different observations to make of the victim. And it includes shaking, unresponsive, crying, scared, angry, fearful, calm, agitated, nervous, threatening, apologetic, under the influence of alcohol, under the influence of drugs, or other observations. And it says document in narrative. All right. Are these typically characteristics of victims of domestic violence?
Yes.
And I'm going to turn your direction to the crime scene now. In the same question, there's a number of different items on here, including location, vandalized, ransacked, and personal property damage, furniture disarray, broken. What is your understanding of why these are included on this list?
My understanding is that these are things that are typically at a crime scene or can occur. So things that we want officers to look for and mark when they take the crime report.
And as with the questions I had on the characteristics that are on the list for the victims, are these items that are also discussed with the police officers in their training to look for in even making the determination whether a crime has taken place?
Yes, they are.
Is there a scenario under which the patrol officers decide that there's no crime, but they see property damage and injury and take photographs?
I mean, every situation is different. I believe one way, if we have a situation like that occurred, then there should be a domestic violence incident report. So there is a place to document your observations and statements from people, and a reason to have those photographs.
Even if ultimately the officers determined that it wasn't a crime.
And yes, that's why domestic violence incident reports are reports where there are no crime, and that is why we have them, so we can document and have a history of calls and see, in case there is another call in the future, that there is prior history of any type of domestic call, even if it was not ultimately ruled a crime.
Would that incident report include if there were interviews with witnesses and if there were any photographs or notes taken?
Yes, there is still a narrative that is written where everything, the officer's investigation and observations and any photographs are listed.
And was there an incident report in place in May of 2016 for patrol officers to use in domestic violence calls?
Yes.
Could you please describe the purpose of an incident report as of May 2016 and what was included typically in an incident report?
So the purpose of domestic violence incident reports were to record when officers responded to a call of domestic violence that did not result in a crime. They are actually required by state law for us to document every domestic violence incident that we respond to. And in that report, it's the same. I keep calling it a face sheet. That's not the official term, but the same as a crime report that we would take it on, but you fill out the information. You just do not list a suspect because we have no crime. It's the victim who was in fear that the other party may cause some type of danger to them, and that other party is then listed as a witness. And then there is a narrative that is included, the same type of narrative that would be in a crime report, where you would write down your source of activity. The officers would put their source of activity and then document their investigation. The statements that anyone made, as we ask on domestic violence calls, what type of relationship it is, how long they've been together, any prior incidents of domestic violence, all that would be included in the narrative of an incident report.
And would any photographs or other notes also be included in that incident report?
Yes, they can be, if there was anything that they saw that officers believe needed to be documented in there. And
where would an incident report, and I'm again back in May 2016, where would that be filed or stored once the patrol officers were done with their shift for the day?
The officers would turn in their reports, including any incident reports, to the watch commander, who would read over it and sign it off. And if it is approved, it would go to our records unit at that division to create a report number on it. And then it does get assigned to a detective, just so that we have it on file in case there's any future incidents.
Do officers at some point have to make a determination as to whether domestic violence has occurred?
Yes, they do.
Okay. What criteria do officers use to make that evaluation?
They use the interviews with the parties that are there, what they observe at the scene, even what they observe, like the demeanor of the victims and the suspects. Every situation is different, but it's really like taking in the whole 360 of where you are and what's occurred, so they can get all information to make that educated determination of a crime has occurred.
Can you just generally describe for me the circumstances under which a domestic incident report is used?
We take a incident report when we determine there is no crime, but that one of the parties is in fear that either their life was in danger or they could be a victim of some type of serious bodily injury. So the third incidents you would have, or where we don't take the incident report, is where both parties state it was an argument, there was no physical injury, both parties say we weren't afraid that the other was going to do any type of harm to me.
Okay. And so in that case, in that third case that you just described, would there be any documentation required typically?
On that third one, when we don't have the fear, so it makes it no incident report, it's only documented on that daily field activity report.
Ms. Meadowhoff asked a line of questions earlier on in the deposition about victims of domestic violence being reluctant to come forward and speak up. Do you recall that?
Yes.
Is that a significant problem in dealing with domestic violence calls?
Yes.
Is that a problem that you have personally experienced on your own calls?
Yes.
Okay. When confronted with a person who's unwilling to make a statement, is there much that a police officer can really do if you have somebody who just refuses to make a statement and refuses to indicate that they have suffered violent abuse?
It's not too much. Usually we teach them to talk about the cycle of violence and power and control, and see if we can start a rapport with the victim and get them to discuss. But if they really don't want to tell us what happened, we can't force them.
If a potential victim has visible injuries, or that there are indications at the scene that there has been some sort of violent episode, does the fact that the potential victim declines to make a statement mean that the officers can't go forward?
No, not necessarily, because they would need to investigate more, but you do have the visible injury and evidence of some type of struggle, so they would need to try to get that probable cause to determine that it was a crime that created that injury.
There were a number of questions asked about if observed injury, if observed property damage, back and forth, and both of us have asked you a lot of questions about this. And so I just want to make sure that it's very clear. If a police officer responding to a domestic violence call sees injury, regardless of whether the victim cooperates, what is the police officer's obligation? This is as of May 2016.
To do an investigation to determine if that injury was a result of a crime.
And that investigation would include what?
It would include interviewing anyone that is at scene, seeing if there's any type of physical evidence of altercation, or depending on the story that was given, if there's corroboration of that, seeing if there's any witnesses. Kind of depends. Each one's different, but just doing a thorough investigation.
If one of the other witnesses took the officers through the entire premises and showed broken glass, spilled wine, and a number of areas of disturbance and vandalism, what would the officers' obligations be then?
The officers would still need to determine if there was enough evidence there from these witness statements and the things that they're seeing to determine if this injury is a result of the crime.
What discretion do the police officers have when they see an injury on the victim when they report it to a domestic violence call? And this is as of May 2016.
The officers still need to do an investigation if there is a visible injury because they have to determine if it was a crime.
So one of your roles, if I understand it, is to make a determination of that the police, the LAPD as a whole, how you're overseeing how they respond to domestic violence calls, correct?
Leading.
Yes.
And let me ask it just a little bit differently. In making the determination of whether to create an incident report, what, if any, factors can the officer consider if the victim does not want to press charges, but the officer still believes that an incident report is appropriate under the circumstances?
It would, if an officer determines that there was not a crime, yet there was enough there, and guess what I'm trying to say? I mean, the purpose we have to think about, that we tell the officers the purpose of domestic violence incident report is for documentation of incidents, because we know with domestic violence there's usually a series of incidents that happen, and not all of those are crimes. So for us as officers, we document those so in the future, if there is a crime, we can go back and say there have been all these other incidents. So as officers, we kind of take that into our analysis of the scene, and if we can't determine whether a crime has happened, we have to think about, do we need to document this so maybe sometime in the future people know that this happened.
All right, thank you. Ladies and gentlemen, let's go ahead and take our lunch break at this time. Again, do not do any outside research and do not discuss the case with anybody, okay? We'll see you back now. All right, so we'll be back at 1:45. Is your next witness on a deposition, or it's going to be live? All right, so we'll take care of it.